Hello and good morning. I have moved my mic back, so hopefully I'm not yelling at you. Sorry, Gabby. Good morning. Happy Monday to you guys. I am Alternate Jur. Thank you for joining me. Good morning, Gabby. Good morning, Stormy. And sorry I made you jump. Wake up. All right, so uh today's gonna be a shorter stream because I have storms coming in supposedly, and the chances of me losing electricity if a storm is coming through is 100%. Plus, my oldest Dane is scared to death of storms, so I will need to deal with her. If she even hears the faintest roll of thunder, um, she panics. So, and not only that, but we have kind of a weird week because we'll have Blake Scanlon's sentencing on Wednesday and Jesse Krzyzewski's sentencing on Thursday. So who knows how long those will take. So I want to be able to do those and not be kind of scrambling all over the place to get to those and get back to something. Now, if something comes up, then we'll go for it. But right now, I haven't seen anything. I have stuff. I just haven't seen anything coming up, and we need to get through this week. And remember, I will not be here next week. I will be viewing the eclipse alone. So I told my husband, like, I'll just go play Total Eclipse of the Heart while I'm out there I'll do video, not with my phone pointed at the eclipse, but just when it goes to total darkness. And he told me just to play all by myself instead. I was like, that's sad. That's sad. So I won't be what? I won't be here on Monday, a week from today. I'll be here Wednesday and Friday this week and not Monday next week. Is that what you're talking about? Okay. We got that cleared up. Don't let me forget to do what you asked me to do as we get later and make sure everyone is here. Okay, so I was trying to find the sentencing hearing for the woman, Jeanette Gordon, that we watched on Friday. I have been through all of the videos that I can find date-wise that is supposed to be around that, and I can't find it. So, but that led me to a little bit more information about this woman, and it'll probably change some of our minds. Not Hamilton's and not Roseanne's. They're gonna be like, "Told you so." Uh, yeah, this woman she has some history. Uh, I wasn't sure if this was her or not until I read the state's appellate response that they gave, and then I thought, "Yeah, that's her." Because that describes her, and I don't know how many people are running around where she lives with the exact same name, spelled the exact same way. It's kinda different. Stormy, are they looking at the parents and his disappearance? I saw something on it, and I wasn't able to go watch it, but I thought, "Gosh dang it. Can these parents just not be nice to their kids?" I saw, um, up in that Elkhart region where this trial took place, um, they just found a 4-year-old unalived. So, I haven't read that. I'm not sure if the parents are involved in that too, because why not? Yeah, it just gets I hate to use it, just gets old, but it just gets old. Like, I don't understand. It seems like it's so rampant, these parents abusing and torturing and unaliving their kids. I don't understand it. Okay, well, right back to our gym that we were talking about Friday. So, no, the 4-year-old is Ariel Garcia in Elk. It's on the Elkhart County site. I think I'm scared to click it because I don't want it to start playing. I assume it's local or maybe it's old because this page I have up is older. So maybe it's not. Maybe he's already been decided. I'll look in a minute. I don't want to lose my page. Okay, so in 2016, July of 2016, Jeanette Gordon was charged with battery by means of a deadly weapon. Yeah, I have to look at it closer, Stormy. I have not. I've kind of looked at it, but I had a busy weekend. No, you're fine. Uh, so she was connected. I'll play the video in 2016. She had those charges brought against her. She pled guilty in November of 2016, was sentenced to 4 years suspended and 1 year reporting probation. So slap on the wrist for, you know, whatever. So that's our woman. I'll try to expand it here, but it got blurry when I did it a minute ago. So that we couldn't see her. And hopefully this is good. So let me know how the sound is. Please, always.
New information in an early morning shooting as well. Elkhart police arrested this woman, 46-year-old Jeanette Gordon. They say she got into an argument with 21-year-old Chuco Dominguez. Now, police say Gordon shot him in the leg after the argument turned physical. She was arrested on suspicion of aggravated battery. No word on the victim's condition.
Happy Easter. So that was her in 2016 doing her thing. 21 years old. I don't know why she did it, but she was sentenced. So let's go forward, shall we? I have paper here. Sorry that it's going to rattle. So let's go to, let me make sure I have these in order. I do not. These all took place so close together. Okay, so on 6/8 of 2020, she was charged with intimidation, and it says threat is to commit a forcible felony and criminal recklessness. That was set for a jury trial. And then the jury trial was canceled because of COVID. Yes, that was the lady that spit on the nurse. That's who we were talking about Friday. So that was the first thing I found on her was the battery by means of a deadly weapon. So now, fast forward to June of 2020, June 8th. Remember June 8th. She's charged with intimidation. Threat is to commit a forcible felony and criminal recklessness. Set for a jury trial in January of 21 was when the trial was set. It was canceled in December of 2020 because of the Supreme Court, I guess, suspended jury trials until March of 21. So that was stopped. It was set again for March And then they wanted her to be evaluated for mental disease or defect. That took a long time. So she was found, she agreed to a bench trial finally, and in May of 21, she was found not guilty by reason of mental defect. So I was kind of going, okay, well, she had a problem that day. She was having a mental episode that day. So he took her off, same judge, I think it was the same judge, took her off GPS monitoring because she was accepted into um, an outpatient program by Oaklawn, which I guess, I don't know if it's Oaklawn, it's not Oakland, is their facility up there. The state wanted to actually have a proceeding to see about having her committed, and they dropped that. So it had to be kind of serious. So when I was looking at all this, I'm kind of going, okay, we were kind of on the page of something happened to her. She was having a mental episode and she didn't know what she was doing that day in the hospital. So I was going, all right, we're going to finally kind of get to things. But then so that charge was June 8th, 2020, June 20th of 20. Good morning, Roseanne. We're talking about your favorite person. Talking about the nurse, or not the nurse, the defendant from Friday that was found guilty of battery with bodily waste, and battery by bodily waste or fluid is infected was how the charges read. I don't know infected with what. They didn't say, and I didn't want to know. So she's charged with that in June of 20. There's a hearing set. She fails to appear. They put a warrant out. There's a hearing set. She fails to appear. I know that's all shocking to you guys. Good morning, Adair. How are you doing? She finally, in November of 21, she finally appears by WebEx, and she's going to waive her right to counsel, and she's going to defend herself, which I wanted to find that, and I have not been able to, but I will keep looking. In January of 21, wait, that must be a November of 20. Sorry. In January of 21, there was another competency evaluation ordered by the judge. And that one, you're thinking just a few months ago, she was found not competent to stand trial. But these 3 doctors found her competent to stand trial. Excuse me, in this matter, which we obviously watched. So she changed her mind in February and asked for a public defender at 21. And she goes back and forth. They file for continuance. It's rescheduled to July of 22. She enters a plea on the day that is supposed to go to jury trial in July of 22. She's going to plead guilty. So she's supposed to be sentenced on 8/15 of 22. She goes to the sentencing and she tells the judge that she's not comfortable proceeding with her plea deal, which is an open plea. That's what it said in the court findings. And she wants to withdraw her guilty plea due to her counsel lying to her. So her public defender is out. They've got to assign a new public defender. And that's where we end up, where we were, what we saw. So I still was kind of going, all right, this woman has some issues, which is very clear. Let me get this off of here. So then she appeals. I got to make sure that I have so this is Give me a sec so I make sure I have the right one. I did not have the right one. Okay, so this is the state's response to um, her appeal. One of the issues that um, Jeanette Gordon brought up in her appeal was that the judge denied 2 jury instructions that she wanted to get in, and so they were saying that was enough to her sentence was inappropriate. They didn't let this jury instruction in. They let one of them in because it was between voluntary intoxication and involuntary intoxication. So they let the voluntary intoxication one in. They did not let the involuntary intoxication one in. So when you get down to what happened that day, uh, yes, for me, I kind of started changing my mind. So we have her trial that we watched. She was found guilty. I could not find her sentencing, but she was sentenced to 180 days for counts 1 and 2, which was battery with bodily fluid or bodily waste. Gross. And then 540 days for count 3, which was the battery by bodily fluid or waste and is infected. I just don't know what that means. They were going to run concurrent, and she's going to jail. So she's in jail. Yes. They are very wascally. So she's going to jail. And I've lost a page because in between her appeal, yes, they are. They are so hard on a Monday, too. She files correspondence, not through an attorney or anything, with the judge. She wants out. She wants out of jail. He says no. Once she's out of jail, then she has 180 days on house arrest after that. And she had 1 day credit when she went to jail. So here's the day of what we saw or what we heard about. We didn't see any of it. So at 8 a.m. on June 20th, 2020, Gordon visited the emergency room at Elkhart General Hospital. During the visit, her friend was observed throwing 3 oblong peach-colored pills with dice. I don't get that. And 10 milligrams on the side at the COVID screener. I don't get the dice. Gordon reported she had taken 3 pills, which we had heard she had taken the Ambien, but declined treatment and left. So she leaves. 10:50 a.m. She comes back by private vehicle because remember, we were not sure how she got to the hospital. So somebody brought her back. She was evaluated by Nurse Karen Vandersteen, which I don't think we heard from her. Vandersteen reported that Gordon was alert to self in place, but not time. Gordon told Vandersteen that at 8 a.m. she took the Ambien pills with the intention of self-harm, but she did not want to harm herself. But now she did not want to harm herself. Gordon said, Sarah prescribed her Ambien. I don't know who Dr. Sarah is. And Dr. Sarah is never explained. Gordon also reported that she had used meth for OCD. For OCD for housework. Keeps me focused and real clear. Okay. I don't know. That was just funny to me because Gordon reported she took Ambien to harm herself. She was placed on the 72-hour hold. So she did take meth. They knew she took meth because she said she took meth. Then we did hear from this nurse, I believe, but I cannot say her last name. Yeah. Yes. This totally changed my mind about things. I didn't know. I knew they colored. I knew people that had been up for days, like those little really like detailed coloring books. to keep him occupied while they were up for days and days. So Nurse Carrie, we're just going to call her that because I cannot say those last names and get them correctly. She was assigned to care for Gordon. When Carrie first encountered Gordon, she was calm and cooperative. I will get words out today. So they got the IV, they did the blood draw, they ran the EKG, got an X-ray. She was fine. She was being monitored. She was drowsy, but able to answer questions appropriately. Around 11:50 a.m., which is about an hour after she got there, she started getting agitated, spitting on the floor, and the sliding glass door to the room. Gross. She was attempting to get up or to sit up and get out of bed, but the nursing tech who was in the room with her was able to redirect her and apparently did so for a while because at 12:30, the case manager came in. After the case manager left, now Jeanette Gordon is agitated again. So she's sounds like she's able to kind of come back and forth. I am not describing the spit. I imagine it was sliding down things, and that's gross. That's all you get. So again, she's attempting to get out of bed and leave. Medical staff attempted to de-escalate the situation and get her to calm down. Because they couldn't get to her to calm down, they called security. So then security officer Arlene Miller, who we heard, who was still very angry about this, she's first to arrive. When she arrived, Gordon was yelling, trying to leave, trying to pull out her IV, which just seems so painful. Miller tried to calm Gordon. And I don't remember this, but maybe you guys do, because we were thinking they never told her she was on a 72-hour hold. But this says, and this is the state's response, so keep that in mind, that Miller tried to calm Gordon and explain to her that she couldn't leave because she was on a 72-hour hold. If they said it, I didn't get it. I didn't hear it. Then Gordon began swearing, became more verbally aggressive, and was screaming that they were not going to prevent her from leaving. Medical staff gave her medication to calm her, but it did not help. Gordon then appeared like she was going to hit the nursing tech or push her into a wall. So Miller and the tech pushed Gordon to the foot of the bed, and Miller called for more security. Security officers Mike Nance, who we did not hear from, and Caleb Carter, who we did hear from, arrived to assist, along with charge nurse Christy Ruiz, who we heard from, and Carrie, that Livor. I'm not sure how to say her name. When Ruiz arrived, Gordon was swearing, yelling, kicking, hitting, biting. When Carter arrived shortly after Ruiz, he observed Gordon screaming, yelling, all the things we heard, obscenities, attempting to kick, bite, and strike but the security officer Miller, who was the woman. My argument back to that she may not remember was she was able to answer questions. She just didn't know the time. She wasn't aware of time, according to the state. When security officers, they get the permission to put her in restraints. While they're trying to restrain her, Gordon became more physically aggressive, biting Miller on the forearm, clawing at Miller's arm, and ripping Miller's mask off her face. Gordon was calling Miller obscene names and threatened to find Miller and unalive her and her family. She also struck Carter on the right side of his face, which he kind of downplayed, I thought. He didn't make it sound like it was any... I'm not saying it's right at all. He didn't make it sound like it was any big deal. Like, she hit... Even when he was describing how that happened, he was not as angry as as Miller is. Maybe still. I don't know. Gordon ultimately calmed down after being placed in restraints. The blood tests were performed. She was positive for meth and marijuana. And then we know what she was charged with. And this is here. Prior to trial, Gordon offered four proposed jury instructions on the issue of voluntary action, involuntary and involuntary intoxication. The trial court refused to provide the instructions on voluntary and involuntary intoxication, but did provide part of Gordon's proposed instruction on voluntary action. Also, prior to trial, the state filed a motion in limine. The trial court granted the motion, precluding any evidence on intoxication. At trial, the court denied Gordon's request to reconsider the order on the state's motion in limine, and Gordon stated that during trial she would be offering offers of proof. She offered nothing. Yes, Roseanne. she she's she's excellent. She's an excellent pure delight person that you just want around you all the time. Um, so we know she made no proof of outside. Well, no, sorry, I'm reading that wrong. She made an offer of proof outside the presence of the jury. That's when they brought Christy Ruiz, the charge nurse, back to the stand and questioned her outside the presence of the jury. They questioned the wrong person, in my opinion. They needed the doctor. So I think they could have done better and maybe got some footing with a doctor. Not that she deserved it, but because when they questioned the nurse about the effects of Ambien, even if the nurse knew, she's not going to say it. That's not her place. I don't think. And again, it's just my opinion. I don't want to go to that, Gabby. I would be okay to not go to the mosh pit at a metal show with Miss Gordon or anyone really. I would get too claustrophobic. So I think Carmen had looked it up Friday about the effects of taking too much Ambien, and they were kind of, you could hallucinate. I don't remember everything, but there were effects. I don't know if the nurse was really, if she knew about him. Again, I don't think it would have been her place to say. And excuse me, good grief. Hang on. But when they were talking about the boxes that were checked on the form of why they saw the restraint or why they got the restraints, I was reading. Sorry. It says the boxes checked included delirium, acute confused state, and acute psychosis. And then they asked the nurse about that. Again, I don't believe that would be her place. And maybe Roseanne, you can chime in here, but I just don't think. I think they should have asked the doctor who put that there, because the nurse says that would have been remarks put there by the doctor, so she can't speak to those. And that's what she said. That is a remark that would be put in there by the doctor, and he would make the judgment on whether the patient was in that state and what that means. She doesn't know what the doctor's thinking. So she further testified that in her general experience, this might mean a person was not oriented to the place and time and might be having a break from reality. When asked if Ambien could cause these conditions, Ruiz said she didn't know, but she did testify that she had observed that methamphetamine could cause these conditions. Gordon was not allowed to present this evidence to the jury. That's what that's what I was thinking. I didn't want to take anything away. When trying to take anything away from the nurse, ask the doctor. He's the ultimate decider. All right, so she got 180 days. And then they just talk about how it was sufficient, the evidence was sufficient for her to be found guilty, that the trial court did not abuse its discretion by refusing to give the proposed jury instructions on intoxication, involuntary intoxication, where Gordon presented no evidence that she was involuntarily intoxicated. I think what they may talk about it down a little bit further. I think that would you would just be involuntarily intoxicated if somebody gave you something and you did not give them permission. Like somebody slipped you something in your drink. then you may have a leg to stand on in this situation. She didn't have that. Um, this is where I linked back to the story that I showed you. The very first one. It says she has a criminal history that includes a prior misdemeanor conviction as well as felony battery conviction with a deadly weapon. And she's failed to provide any reason that her sentence should be revised. Let's see. I don't think there was. That was just about the evidence. So her third charge, I believe, the battery with bodily fluid or waste is infected, ugh, is bad. So let me make sure that I have this all. I have read so much. I'm just kind of like, okay. So this says a person who knowingly or intentionally touches another in a rude, insolent, or angry manner, or places bodily waste on another in a rude, insolent, hopefully I'm saying that word right, or angry manner, is guilty of Class B misdemeanor battery. It is a level 6 felony if the offense is committed on a public safety official by the officials engaged in his official duty. That's the nurse. A public safety official includes the emergency medical services provider. Gordon does not dispute that she touched someone or placed bodily fluid on someone, and there was evidence that Gordon bit and clawed Miller on the arm, hit and spit Carter in Carter's face, and spit in Ruiz's eye, which shows it was done in a rude, insolent, and angry manner. Probably, I've never known anybody to spit nicely on somebody else. Gordon claims the evidence was insufficient to prove she committed battery because her actions were not voluntary since she was under the influence of Ambien. She wanted to take the Ambien, so it wasn't involuntary. Yes. And I can't spit, so I would just end up spitting on myself. It would be kind of embarrassing. So a person can show he was involuntarily intoxicated because a substance was introduced to his body without his consent, or he did not know the substance might cause intoxication. Then he can negate culpability for the offenses. She didn't have that. Let's see. It would not be funny to watch. It would not. I promise. I would probably throw up because it would gross me out so much. So we know that she took the pills. She came to the ER once. She came back by herself. I don't know how she got there. It just says by private vehicle. So hopefully she did not drive. And we all know that stuff. I don't know why they're repeating it. Let's see. So they're just talking about she couldn't be involuntary intoxicated because she admitted to taking the pills and why she took the pills, and then she changed her mind. And that's pretty much all the state stuff. Sorry. Let's see. So, none of the testimony proved that taking too much Ambien could result in intoxication that caused aggressive behavior or that it could produce delirium or acute psychosis. I don't know that it could or it couldn't. They just didn't present any testimony saying one way or the other. The physician who checked the boxes indicating delirium and acute psychosis did not testify. Regarding the state Gordon was in, that would warrant checking those boxes. More importantly, there was no evidence that even if Ambien could and did produce these conditions in Gordon, that Gordon was unaware of this when she took the Ambien. In fact, the evidence showed that Gordon reported that she took the Ambien to end her life, so she was aware. So, yes, all this is just about voluntary intoxication, involuntary intoxication. She was wrong. And yeah, this when I just started reading this, actually, I didn't even read the state's response first. I read hers. I read her appeal first and changed my mind. That's how bad it is. Because just they both state the same thing as far as what happened that day. I'll pull hers up. And I know this is probably really kind of boring, but I just want to put it out there that Roseanne and Hamilton were right. we, we were having problems with the procedures. However, same story here. She came to the ER at 8. And she came back. She reported she took the Ambien because she wanted to hurt herself. They put her on the 72-hour hold. She also told the nurse she used meth to keep her focused and, quote, real clear. And that all this is the same. She was calm. They did the IV. They took her blood. They ran they did all this stuff. They both agree on that. And that then she spit on the floor and the sliding glass door. Agree on that. I don't know. They agree on everything. If you just going down here and reading it, they agree on everything. They agree that Miller explained to Gordon that she couldn't leave because she was on a 72-hour hold. So I don't know exactly where her appeal is in this because she is saying everything the state said about what happened is true. She just didn't like the sentence. And she didn't like the sentence because I believe it was outside of the sentencing guidelines. So here's where their fight's going to be. Well, it's not. It's over. The fight is over. This was really a very quick appeal. So they're going to fight intoxication, voluntary intoxication versus involuntary intoxication. There's no standing there, in my opinion, of a non-legal person who has no legal experience whatsoever. I just have an opinion. So that's all just going. I didn't know what I was doing. I was out of my mind. I believe she knew what she was doing. I think that she may have thought, I'm trying to make sure I didn't miss anything, that she got a slap on the wrist pretty much for that first charge, which was a serious one against the 21-year-old and what she did to him. She basically got probation. So she has, and then what's interesting to me is the first time she's found not competent to stand trial in that second case, I think it was, and then just months later, she's found competent to stand trial. I don't know how that works, but 3 doctors said yes. I don't know who evaluated her the first time that said no. So I don't know if she thought maybe she could get out of this again by like, ooh, I'm crazy, and go that way. But I think she probably got what she deserved. So she argues that her 540-day aggregate sentence is inappropriate in light of the nature of the offenses and her character. I wouldn't bring my character into this if I was her. It's not great. For Gordon's level 6 battery conviction, the trial court was allowed to sentence Gordon to a fixed term between 6 months and 2.5 years. Gordon's 540-day sentence is 175 days more than the advisory 1-year sentence for a level 6 felony. The trial court imposed maximum but concurrent 180-day terms for Gordon's 2 Class B misdemeanors. So they're saying that was too much. She shouldn't have had that. At least they were running together, because otherwise you'd have a long time. I think she kind of was where she needed to be. Gordon does not argue that her sentence is inappropriate concerning the nature of her offenses. She bit and she scratched Miller, and she spit in Carter and Ruiz's faces, causing all of them concern about the possibility of infection. She also screamed obscenities at security officers and hospital staff and threatened to kill Miller. Unalive Miller. Unalive. Gordon argues that her character does not support the sentence imposed in light of her mental illness, and she claims the trial court gave too much weight to Gordon's behavior at prior hearings. The trial court considered Gordon's mental illness and commended her for actively participating in mental health treatment. And Gordon's criminal history is relatively minor, consisting of a misdemeanor conviction and a felony battery conviction. I don't know when it gets major. Yes, so she had, I don't remember, they didn't, if they listed the doctor, didn't see the doctor in the first time that she was declared not competent. And then there was at least 2 psych docs, and I'm not sure what the third doctor was, that evaluated her and said she was competent to stand trial for the one we just watched. So she had been heavily evaluated over a couple of years or less. It was a very short period of time when all these things happened. The court also noted and provided example of Gordon's disrespectful and combative behavior throughout the trial proceedings and contrasted that behavior with her calm demeanor at sentencing hearing. She didn't show up twice. And then she wanted to represent herself. And then she decided she probably should get an attorney. So she got a public defender. Then she accused that public defender of lying. So she had to get another public defender. She wasn't great. Oh, and she also had to write a letter. She either had to write 3 letters to each of the victims, or she had to write 1 letter to all of the victims. She did write the letter. I cannot see what it says. The nature of Gordon's offenses against her 3 victims more than supports the trial court's decision to impose a 540-day aggregate sentence, and Gordon has not persuaded us that her character warrants a downward revision of her less than maximum sentence. So this is them affirming that they affirmed the conviction. They confirmed the jury decision, and nothing was done. They did that. I think I left a page in my notebook. Yeah, I did. And I took it downstairs. Good for me. They had that done. Her sentencing was supposed to be January 13th. And then she appealed it in, I think, February of 23. And the appeal was done March or May. It was really, really quick that they came back and was like, no, there is nothing to see here at all. So, yes, that's our woman. I just wanted to get it out there. I was wrong. Because my thought process was, if she was having issues, a mental health crisis, and she didn't know what she was doing, she should not have been charged with that. I think she did know what she was doing, allegedly, in my opinion, that's all. And thought maybe she was just gonna get a slap on the wrist, and she didn't, and she got mad again. I don't know. I'm very curious about the effects of taking too much Ambien. So she took Ambien, she took 3 Ambien, which I don't know if that would be enough to unalive yourself. God, I have no idea how much Ambien it would take to do that. But so she's going to sleep, and then she took meth. So, like, those are not those are the opposite ends of the spectrum here. Like, do you wanna go to sleep or do you wanna be really focused? Like you say, meth makes you. I don't know. I don't She just obviously was not making good decisions that day. I'm not sure why they were in the hospital to begin with. I don't know about her friend throwing pills is weird, and dice. I don't get that. That was odd. I do believe that that's true, that she just tried to play everyone, and the judge just wasn't having it. That's why I really wish that he would have put her sentencing up, but he didn't listen to me. Definitely. So when she gets out, um, she has to she's I don't need that anymore. She's on house arrest for 180 days after she gets out. She has to do um, I think drug classes or something. She has another class that she has to take, I believe for mental health issues. I would tell you, but I left my page in my notebook like an idiot. Uh, yeah, I was trying to make sure that I was the idiot. I think I was the idiot. I had it all written out. So, and then she's got to do some stuff before she's through with everything. And I forget how long her probation is after all of that, but she's got a while to work on herself. And as she should. I can find it. Give me a second. It used to be they changed it now, which is probably for the better, but I used to be able to look up stuff and it show me everything that, like, you could read all the documents for the most part unless it had a kid or something like that in it. But they've changed it now so you can kind of just see what's happening but not um see like everything, because she had correspondence to the judge in the first one. She was on like work release or some. I don't know if she ever completed her work release in the second one where she was found not competent. She had a lot of stuff going on there, but you can't see any of it. You can just see where they reported, but you can't see what they reported. Did she show up? Did she not show up? Give me 1 second, because I can see what she was sentenced to. One second. Like, I need Jeopardy music playing right now. It's just a very, very, very long record. Like, very long. And the judge kept ordering her to appear in person, and I don't know that that was working out very well. Obviously, twice she didn't, so they had to put a warrant out for her, and I believe she did get arrested for that. But again, I can't see everything. I can just see where she got bond. Okay. Well, you wanna hire her, Roseanne? She'd be great. She'd be a great coworker. You guys could do nursing stuff together. Ooh. Okay, so that's what she got. That's the count 1 and 2. So she got 180 days, 1 credit 1. So then when she gets out, home detention for 180 days. Roseanne, I don't know why. You're missing out on a great person. Substance abuse evaluation, continue with all recommended treatment, court ordered classes, moral. I don't know. Is that recognition? I don't know what that word is. Therapy. Recognition? Can you guys see that? Right. Right. Oh, oh, you can't see my cursor. Where it says moral something therapy. I don't know what kind of therapy that is. Uh you probably have some unalived people outside of your house if she was keeping people out of your trash. You trash. That's all I'm saying. And letter of apology. Either 3 letters of apology to the victims or 1 letter of apology addressing all the victims. So that's what she has to do. She did. The letters are down here somewhere. She got the letters done pretty fast. But she was trying to file stuff with the court on her own. And the court's like, I can't look at it. Apology letters were done by March 1st of 23. So she got those done pretty fast. I mean, what else is she going to do? So then she files her appeal. So she filed her appeal in May. Sorry, by 8/17, they had affirmed it. We already watched the trial, Adair. We watched the trial Friday. We were all we were Roseanne and Hamilton, who work in that field, they were like, she's guilty. She should not do this because she was attacking medical staff. There were some of us on the other side of that, of she didn't know what she was doing and she got some pretty serious charges for it. And they didn't tell her what was happening. But then when you go back and you look back in these documents, they did, on both sides, the state and the defense, say they did tell her she was on a 72-hour hold. And she admitted everything that she did. So, and everything that she took. So I was just showing it because it changed my mind. And I wish Chrissy was here because she probably would have her mind changed because she was definitely on the side of she shouldn't be charged with any of this stuff. But I think she got what she needed. And guys, that's all I have. Except, Gabby, do you want me to hang on to that? Because Hamilton isn't here. And I can hang on to it. I can play it Wednesday or I'm not sure what to do with your with your request. Okay. I will. By the way, when I was going baby shower shopping with my daughter-in-law yesterday, I saw a turkey, and it made me laugh. He wasn't in the road, though. He was out of the road because he wasn't stupid. All right, you guys. We will do Blake Scanlon's sentencing on Wednesday. I expect there will be quite a few maybe victim impact statements read that day, arguments. I think that'll take a little bit of time. I expect on Friday, when they do Jesse Krzyzewski's sentencing, there will also be a few victim impact um, statements read. And her sentence is straightforward. It's life. That's it. No parole. That's just the way Wisconsin does it. So I wish they would kind of do it like Florida, because Florida, you know what it is. So if you're found guilty, I don't know if you've watched trials down in Florida, they sentence you like right there. Unless it's a DP case, and then it's got to go back to the jury for them to decide if they're going to give you that or give you life. But it's all done. It's kind of like Texas. It's all just done. There's none of this months and months of this. Jesse Krzyzewski's trial ended in November, was when she was found guilty. This is crazy that it's taking this long to sentence her to what the sentence is. There is no other sentence. But it's the first live trial I did, and I know the first video is really quiet because I did it and then I uploaded it. So I know. And I'm sorry. I fixed it after that. But YouTube is trial by fire, and you either make it or you get burned a little bit sometimes. um, Also, this week, I'm going to keep an eye on it. See, that'll be Thursday, I think. Ty Tucker, uh, his hearing is this week, I believe, on the 4th. So we'll take a look at that. Um, See what's happening there. If you guys haven't, I guess depending on which side you're on of his case, maybe either side. He's doing updates every Friday on his YouTube page, and they're interesting to kind of see what's happening and what's going on in there, and just to you kind of get a picture into his thought process on things, and it answers a lot of questions generally, and he is very good at interacting with his chat, who asks good questions too. And I I am mixed on if he calls Captain Phelps to the stand, if she won't just plead the fifth, which won't look good. But I don't think she would answer any questions. I really don't. Yeah, I saw that. I saw that him answer. I wish he'd put the questions up on the screen. I don't think he's figured it out. Adair, that can be scary. Congratulations on your granddaughter driving now. And it does go by very, very quick. My daughter-in-law has the baby's not even here yet, and she is already worried about how fast the time is going to go by. And I told her, you can't look at it that way. You just live in the moment, because it's where you have to stay. Because if you're just looking ahead at the future all the time, it's coming. There's nothing you can do about it. You can't stop it. It doesn't do you any good to dread it. You just have to enjoy where you're at and kind of accept where you're going. And one day, those words will be used back on me. So I already know that, and it's fine. It's fine. I was pretty good at doing it, and then I had some moments where I wasn't great. Some, then you just kind of things hit you. But I enjoy my kids as adults. I enjoyed my kids as kids, and that's just where we are. So, I mean, you can't stop time. If we could, that'd be great sometimes. Sometimes it wouldn't. So, all right, guys, I'm going to jump off of here. I'm going to hope for no storms today so I don't have to deal with a panicky dog. Yes, share. And we are also in the 1 year since we had the big tornado I told you guys about a couple weeks ago. That's like right now is the 1 year anniversary. And we're just up there number wise today. So I'm just hoping for everything passes us and nothing happens to us. So sorry, this is short. I hope you guys weren't completely bored with everything. I thought it was interesting to give the background on what we saw, the person that we were watching. So if that was boring, I apologize and let me know, and I won't do it again. I'm that way, Gabby, because we don't hear everything at trial. And like I've said 100 times, if it's not presented at trial, it doesn't exist for the jury, as far as the jury goes. So they didn't talk about her, any of her priors. They didn't talk about anything. They didn't need to. But it was interesting to me. Her appeal was very interesting to me. When I found that, I was like, yeah, I'm done. You're guilty, lady. So, well, go enjoy the rest of your Monday. Thank you for being here. If you can hit the like button on your way out, I would appreciate it. If you're watching on replay and you can hit the like button, that would be fantastic as well. So I will see you guys all Wednesday. We'll do Blake Scanlon, and I will look to see the time on that and see what time I need to start. So we will go from there, and I'll see you then. Have a great Monday.